Howdy, my name's Brian Foley. I'm a criminal defense lawyer here in Conroe, Texas, and I represent folks who've been accused of a crime in Houston, Conroe, the Woodlands, and the surrounding area. Today we're going to continue our series on the dirty little secret in criminal law. Today's crime is going to be DWI open container. So what is an open container? An open container is a glass, a bottle, or any other receptacle that has alcohol in it and is opened. So an open container would not be closed beer cans in, behind the passenger seat. It would be an open beer can that has any alcohol left in it. A few drops, that's any alcohol. And so generally an empty beer can is not going to be considered an open container. Another thing you may be thinking is like, what about old beer cans in the bed of my truck? Okay, that is not the passenger area of the vehicle. And so you can have an open container in the trunk or in the bed of your truck, or actually in the back part of an SUV. It's sort of like the spring break exception. The back part of that Suburban where you've got the cooler, they're going to kind of expect, some people are going to have to transport alcohol from different events. So there's sort of an exemption there. But if you've got alcohol up near the front part of the vehicle, in the passenger area is what it's called, then that could be an open container. And if you're found to be intoxicated while driving with an open container, you're going to be subject to a little bit of a higher punishment range. So what is that higher punishment range for a DWI open container? Well, a normal DWI, if it's your first offense, is a Class B misdemeanor, and it has a minimum punishment of 72 hours in jail, maximum of 180 days in jail, and a $2,000 fine. The difference between a DWI first and a DWI first with an open container is that minimum of 72 hours gets increased to 6 days in jail if they have an affirmative finding of the open container. That means if the state proves at trial that not only were you intoxicated above the legal limit, things like that, or maybe had lost the normal use of your mental or physical faculties, but they also prove that you had that you had an open container in the vehicle, and specifically in that passenger area. So what's the dirty little secret with DWI open alcohol containers? First, it's that most prosecutors don't really care about the open alcohol container finding. They will waive that frequently if you just ask them to. There's not any reward for that. It doesn't change the offense a whole lot. The 6-day minimum part is not typically part of things. If you take a probation, the 6-day minimum really doesn't come into play unless you get revoked from that probation for some reason. The other thing is that if you have an open alcohol container in your car, that sounds like a bad fact. It's not good. It shows you're probably drinking in the car, right? But if your blood alcohol level is right at 0.08 or maybe 0.09, having the open alcohol container in the car would show that you were continuing to consume alcohol right up until the point you were arrested. And people metabolize alcohol by their alcohol rate goes up, and then it peaks, and then it goes down. Okay? And if you were still on the way up, like an hour before the blood test, and the blood test is that peak at 0.09, you might have been below 0.08 at the time you were actually driving. So while it could sound like a bad fact for us, it could be something that we use and maybe even get the Department of Public Safety expert to testify that you may not be guilty at all because what's called extrapolation evidence shows you may have been under at the time of driving.